All rise and able.
Yes, Mr. Regan.
My Lord, I think as we closed yesterday, I was coming to the end of my submissions in relation to investigation costs, and in particular one or two observations in relation to the facts and the evidence. I wonder whether perhaps I might just finish that off briefly before turning to a different topic. My Lord, the next point that I wanted to make was that at J1183, the judge found that it was insurer's 2018-19 scheme which most closely approximates to the work necessary in order to rectify damage at the end of the period of insurance. Now, of course, my Lord, that's subject to insurer's grounds 1 and 2, but that's what the judge found. Now, what we submit, subject to those grounds, is that there would therefore be no justification for the judge to award Sky the costs of further investigation in relation to areas of the roof which it had failed to prove had suffered damage as at the end of the period of insurance. Because either way, no investigations are required because the indemnifiable damage has already been identified by the judge, and to the extent, therefore, that any further, in inverted commas, damage is revealed, that will be uninsured. Now, my Lord, in addition to that, it's just worth pointing out that very substantial investigations have already been carried out in relation to the roof, in particular, those carried out by McDonald. And can I just please give you a reference as to Mr. Coulson's comments on those investigations? I'll come back to it in a moment, but the reference is his second report, paragraph 5.6, which you'll find at Supplemental Bundle D, tab 43, page 740. My Lords, moreover, even on the rag maps upon which the claimants rely, a substantial number of the cassettes simply don't require any repair. Now, my Lord, I don't need to take you to the document, but can I give you the reference, because it is an important document. It's Supplemental Bundle C, tab 41F, page 678A. That is the legend for the rag maps which were prepared by Mr. Elliott at the direction of Mr. Smith, the claimant's wood science experts. And you'll see there, amongst other things, even the red category includes items such as mould, so timber where there is mould. And the judge has already found that mould doesn't constitute damage, in line with the very clear evidence that was given by Mr. Coulson, who was the wood science expert whom the judge preferred. Over and above that, the amber designation only indicates staining, which it is said could be indicative of potential damage. My Lord, that is not damage, and that doesn't come close to proving on the balance of probabilities that there is damage.
So no cost of investigating that, even if there does turn out to be damage? Or do you get the cost of investigation if there does turn out to be damage, but not if there isn't?
But my Lord, these are submissions directed towards the point that there should be no further investigations at all, because to do so, what I was going to do in a moment is summarise what I think we might have got to yesterday. But at the moment, we're looking at this question of what it is that's taken place. Are any further investigations, in fact, needed? And for the reasons I've just given, in my submission, no, they're not. And the rag maps on which the claim for lifting the lid, which is the shorthand for what are said to be investigation costs, and you heard my submissions about the peculiar nature of those yesterday, but those are based on the directions given by Mr. Smith as to what constitutes damage, and we, in our submission, that is much more expansive and a misconceived approach to what damage really is. Now, I'll have to address that in a bit more detail when we come on to our grounds 1 and 2. But, my Lord, that's the submission, and that's set out, for your Lordship's note, the Supplemental Bundle A, tab 10F, pages 172 to 181. Now, the reference for the judge indicating that mould wasn't damage, that is paragraph 151 of his judgment. And we would submit that when you apply the correct test for damage, in other words, damage doesn't include mould, it must be a condition which requires repair or replacement. The number of cassettes which might require repair, even on Sky's own case, is dramatically reduced. Now, my Lord, can I just give you a couple of references? In the interest of time, and I do hope that you'll forgive me for taking it in this way, but can I just invite your attention to paragraphs 5.4 to 5.6 of the second report of Mr. Coulson, which you'll find at Supplemental Bundle D, tab 43, page 740. Mr. Coulson has looked at the 188 cassettes upon which Sky relies for the proposition that there is upslope damage. And Mr. Coulson says in relation to all of them, as at 2017, none of them would have been damaged. They would all have been in good condition as at 2017. Now, that's the evidence of the wood scientist on whom the judge relied as providing the most probative evidence as to what the conditions of the cassette was in 2017. He also describes the process of lifting the lid as a rather drastic approach. Those are his words. And in his view, would only be exposing as new bays which have no water ingress in them. Instead, what he said was that I consider that the approach that McDonald have taken to date, in which Mr. Elliott discusses in his statement, to be a reasonable way to assess the cassettes, if in fact any investigations are to be carried out. That's simply with the benefit of photographs. He says it's perfectly possible to assess the condition of the timber in that way.
That's which paragraph?
And that is paragraph 5.6, and that's page 740, behind 10.
Oh, I see, sorry.
And I should just give you the reference. Yeah, I'm so sorry, but
No, you moved from what to a reference to what the judge had said about lifting the lid,
Yep.
then to reading out some further matters. I thought you were suggesting that's what the judge had said. That's what Mr. Coulson.
That's Mr. Coulson, and that is page 740, paragraphs 5.4 to 5.6.
Sorry, just so I'm clear that I understand what you're asking, what you're trying to do here. I mean, you're feeding us sort of references to the evidence about lifting the lid and whether it's required or otherwise. Are you expecting this court to reach a conclusion on that factual evidence?
But Lord, I say we had a number of exchanges in relation to investigation costs yesterday. I'm now addressing the question of whether or not it would be reasonable for investigations to be carried out.
Yeah.
And on the basis of the evidence that there is. Forgive me.
Sorry, just pause, rewind. Your first proposition as a matter of law, at least at the start, was no investigation costs, full stop, unless they actually found damage. I think you then either, instead of that or as a fallback, said, okay, if there are investigation costs, they should only be reasonable investigation costs. Yes?
Yes.
So far? If that's where we end up, are you suggesting that we actually, on the evidence, can say what is reasonable and what isn't? But wouldn't that be a matter to be remitted to the judge, who actually has a much better overview of what may or may not be reasonable in the overall context of the evidence? Because you're just picking little bits out of the evidence, and I'm listening on the basis, I'm very grateful we've got a transcript, and I'm not attempting to keep pace with writing down the references.
Of course.
What are you actually asking us to engage with?
Lord, so far as any submission depends upon reasonableness, then the submission will be on the basis of the evidence as it's already been found and the determinations that the judge has already been made. There is no basis upon which it might be contended that lifting the lid or investigation costs should be allowed, or that there should be a lifting the lid.
Are you essentially saying the judge has found that the 2019 scheme doesn't need adjusting for investigation costs of lifting the lid, and the appeal on that ground should be rejected because there was an evidential basis on which he could treat that as unreasonable?
There was a very sound evidential.
Is that how the argument arises?
Yeah.
I see.
Now, Lord, what I should do now, and it's extremely helpful that Lord Justice Snowden puts it in that way. One of the things that struck me at the end of yesterday, and perhaps overnight, is that we covered a very great deal of ground yesterday by reference to a number of different examples, a number of different circumstances in which you asked me, well, what would the position here be, what would the submission here be, and so on. I wonder whether perhaps what I might do is summarise insurer's position. Now, of course, it's open to the court, they will accept it or reject it. My main concern is just to make sure that you've got it. And I wonder whether perhaps I could do that if you don't mind.
Yes.
If that would be convenient. Can I also as well just flag up, because I'm going to come to it in a moment. I was thinking about one of the points made by Lord Justice Snowden in relation to the Renos and WASA, and I think supported by Lord Justice Popplewell. And the point I think that was being made was that of all the paragraphs in WASA to which Lord Sumption referred, the one that he picked out was paragraph 39. And it seemed to me that I've got to at least try to address that. And one of the things I'll do in a moment is try to do that, I'll come to that in just 2 or 3 minutes, if I may. So, my Lord, so far as investigation costs are concerned, we submit as follows. First of all, you have, I hope, an extract from Colinville, which simply just makes good the point I was making yesterday in relation to household policies, that there are buildings policies which include trace and access cover, which are extensions. I don't say any more about it than that. It's simply offered, because I think I was asked the question at some stage during the argument yesterday as to similarities or otherwise between this policy and household policies. The point I was making is that those policies are written on a damage occurring basis. Of course, there are then a plethora of other terms which may well be different, some may be similar, one's simply not in a position to say without looking at particular policies. But my lord, ultimately, what this court is concerned with is the proper construction of this policy and the allocation of risk which it achieves between large, sophisticated commercial parties. And in our submission, although hypothetical examples plainly help in terms of testing certain ideas and propositions, ultimately it's the terms of the policy which must govern the policy's meaning. And that exercise of construction in our submission must involve the construction of the whole of the policy, including the extensions contained in the memorandum. Now, our submission is this, that even if it's right that the extensions in relation to professional fees and loss minimisation attract sublimits, and they do, it doesn't follow from that they don't provide any assistance as to the proper construction of the scope of cover included in the insuring clause, or indeed the commercial bargain struck by the parties. Because we submit the fact that those matters are the subject of extensions at least provides some sort of clue or pointer as to the scope of cover that's included within the insuring clause. My lords, we would submit that there was a suggestion, I think, yesterday that, well, could it just be mere surplusage? We would submit that's not right, that these are extensions which, as I understand it, are separately and commercially negotiated, and an additional premium is paid if those extensions are to be obtained. Now, could I just invite your attention very briefly to the policy? I know you've been shown quite a lot of aspects of the policy, and I don't want to detain you more than you need to do. But if we could just look at its terms. First of all, so far as the insuring clause is concerned, it is physical damage occurring during the period of insurance. The measure of indemnity, perhaps I should just take you to the relevant page. It's page 770.
May I just understand, so you said you were summarising the position. You then said investigation costs. Have you finished with investigation costs?
My lord, I'm still on the general position in relation to...
So we're just dealing with
investigation costs. Yes. And then I'm going to come on to the period of insurance more generally, the question of developing damage, and then to try to provide an answer to what Lord Justice Popplewell, I think, put to me as a matter of juridical principle, which categories of loss or damage might fall within the scope of cover, and if we have an answer in relation to that, what the basis of that answer might be. I will endeavour to do that right at the very end of this passage of submissions, if I may. But on the question of investigation costs, could I, first of all, just invite your attention to the insuring clause which we've looked at. There's then the basis of settlement clause, which indicates that in settlement of claims under this section of the contract of insurance, the insurer shall, subject to the terms and conditions of the contract of insurance, indemnify the insured on the basis of the full cost of repairing, reinstating, or replacing property, loss, or damage. And the Lord, that, of course, is property lost or damaged during the course of the period of insurance. Now, we submit that costs which are incurred in gaining access to damaged property in order to repair it might, subject to the facts, form part of the costs of repair. And that's going back to an exchange that we had, I think, during the course of the end of yesterday morning. However, absent a specific extension, we submit that the costs of investigation are not covered by the policy. Such costs do not concern repair, reinstatement, or replacement, but on the contrary, they form part of an exercise which is performed in order to find out whether repair, reinstatement, or replacement is required.
Sorry, I need to ask you to repeat that simply because I thought you said that if there was damage, the cost of gaining access to effect the repair was covered, and then I thought you then said it wasn't.
But that's
can you
plainly a fault in me, my lord. That's the impression.
Are you saying that it's not covered where there is no damage occurring during the period which is found, or what?
my lord,
I'm sorry. It'll be on the transcript, but I didn't follow it as you said it.
That's my fault.
Okay. Well, I wasn't alone.
That's obviously my fault. My lords, the submission was that costs which are incurred in gaining access to repair damage can, depending on the circumstances, they can amount to the costs of repair of damaged property and fall, therefore, within the ambit of repair costs.
Where that damage, I think you say, limited to where that damage is damage which occurred during the period.
During the period of insurance, absolutely.
Right.
Yes, got that. Yeah. Now, absent a specific extension, the costs of investigation are not covered by the policy, because by reference to matters such as the extension for professional costs, they simply form outside the scope of the cover that's provided. And the reason for that is investigation costs we submit are not costs which concern repair, reinstatement or replacement, but rather they are costs of an exercise which is carried out to find out whether you need to carry out repair.
So that even if the investigation identifies property that needs to be repaired, it's just not covered, absent an extension.
One could, yes, as a general proposition, yes. One might imagine that if you, for some reason, are breaking into a cassette, looking at a cassette, you see that there is damage that requires repair and you access it. Depending on the precise factual circumstances, that, provided it's with the intention of rectifying damage, the breaking into the cassette, we could see how, in some circumstances, that could be said to be encompassed within the cost of repair. But investigation costs, generally, we submit are not covered absent an extension contained in the memoranda, and there is no such extension.
So, for example, professional fees of those who are advising where the investigation should take place,
yes,
they're not covered.
They're covered under the extension for professional fees, yes, but only because there's an extension. And they, we submit, give a pretty powerful point. If you remember the language of the professional fees extension, it covers professional fees. Perhaps we should just look at that extension. Perhaps I could just invite your attention to it. It's page 774.
But I don't understand that, because the extension is for professional fees necessarily incurred in the repair, replacement or reinstatement. And I thought that was, you said, it was those same words appearing in the basis of settlement that excluded costs of investigation. So how are they included in the extension and excluded in...
No, they're simply not within the scope of cover in the insuring clause.
But how are they within the scope of the extension then?
Because the professional fees, so far as the costs in question relate to professional fees, what's provided for is the insurance in respect of the property insured extends to include an amount for architects, surveyors, consulting engineers, legal or other professional fees of similar nature necessarily incurred in the repair, replacement or...
Yeah, when you were making submissions on the basis of a settlement clause, you said that investigation was not included because it didn't fall within the words repairing, reinstatement or replacing.
Yes.
Well, how is it then included within the extension? Because it's still only necessarily incurred in the repair, replacement or reinstatement. But so why would professional fees looking be any more included in the extension than it... it's the same wording.
My Lord, we submit there's a material distinction. That the insuring clause, the basis of settlement, is talking about physically doing the repair work.
Yeah.
What is provided for here is that you only recover professional fees which are necessarily incurred in relation to that if you have the extension. Absent the extension, what this is telling you is that those fees are simply not covered within the basis of settlement.
Yeah, but it's still, even within the extension, it's only if necessarily incurred in the repair, replacement or reinstatement.
Yeah. And we would submit that shows just how, or gives an indication as to the scope of the cover. Even professional fees which are incurred and necessarily incurred in repair, replacement and reinstatement, those only fall for cover because they're included within the extension. If the extension wasn't there, they wouldn't.
Right.
That's the submission.
I'm puzzled too, because I understand that you're suggesting that this covers experts involved in an investigation.
In deciding where to look. The question you were asked by Lord Justice Popplewell was, so what about the professional fees of an expert telling you where to look?
No, this is professional fees, which are necessarily incurred in repair, replacement, or reinstatement. One can imagine them designing the repair works. It's that. It's not. These are not costs concerned with some sort of general investigation.
So it's not covered. It's not covered under the extension or
No. The purpose of referring to the extension is to use the extension to give a clue as to what the scope of cover is under the insuring clause. Now, the general...
I understand the submission. The parties might, in a private eye way, say, surely some mistake. But
Well,
I'm afraid at the moment, and I'll look at the transcript, I don't want to delay you. I'm not sure I do understand the submission, but private eye or no private eye.
The bold submission, and perhaps the thing that is most important that you know is our submission,
yes,
is that investigation costs are not covered as a matter of general.
That I get.
But perhaps that will do for the time being. If I can come back to it, I will. But perhaps then, with that, can I just say then the alternative position is that I'm wrong about that, then investigation costs are only recoverable to the extent that they're reasonable, and that was the purpose of some of the submissions I was just making. Now, but can I then just turn to the period of insurance? And can I just address the fire example? We say that so far as that's concerned, damage after the period of insurance simply isn't covered because that is the bargain that the parties have struck. What might be the position in relation to successive annual policies, we say is immaterial. This is a project policy. The cover which it provides is confined to damage to the contract works, which can be proved to have occurred as at the end of the period of insurance and nothing more. And allied to that, my lords, is this submission, that insurers are not guarantors. They don't guarantee that Sky will be covered against any losses which might arise. But on the contrary, theirs is a carefully circumscribed bargain or promise that's made, which reflects the premium that's paid, and it's to hold harmless in respect of damage, and just damage up to the end of the period of insurance.
I understand that submission. But
Commercially,
if you had said to the parties, what you have agreed to and what this policy means is that you've agreed to cover insured damage in circumstances in which the inevitable consequences of that occurring are uninsurable. Again, they might have given you the private eye answer, mightn't they?
Well, my lord, we say that the bargain that's struck is damage up to the end of the period of insurance. And my lord, can I just underline that by reference to another provision of the policy? Could we just turn very quickly to page 747 in core bundle C? And it's just in relation to the definition of the period of insurance. But as you know, this was extended over a period of time. But initially what was provided for was the whole period of the project, estimated to be 23 months from and to local standard time, at the project site, including testing and commissioning, and thereafter automatically held covered for further periods, if required, at additional premium to be agreed by the leading insurer. Now, my lord, we say that is another pointer or clue to the limited scope of this cover. It's damage occurring within the period of insurance. If you want cover for damage which goes beyond it, you can have it, but you've got to pay for it, and it's got to be separately negotiated and agreed. That, in our submission, is what this provision is saying.
Yeah, but I don't think that really, with respect, answers the point that's just been made to you about leaving one of the parties. You have to look at both parties, not just, as it were, one party, with an uninsurable risk.
Well, but look, that goes back to the point that insurers aren't guarantors. And these are sophisticated parties who know what it is they want.
So was Mr. Justice Butcher, I can't remember the case it was, we looked at it, I think it was Mr. Justice Butcher's judgment where he took into account, as part of the matrix, I think, in interpretation, the position the parties would be left in if there was as it were, no ability to reinsure. I think it was Mr. Justice Butcher.
Yes, various eateries case.
Yes, various eateries. Yeah. Well, was he wrong to approach the matrix? Because it's not just the words. You look at the words; they're not just. I mean, obviously, I fully understand why you say you must look first of all at the clause in the context of the agreement as a whole, which is what you've been doing with the extensions and the memoranda. But then there is the matrix, the commercial matrix, in which both parties find themselves. I mean, he's not wrong to approach it in that way, is it?
Well, my lord, that, in my submission, takes us back to the nature of this policy. It is a project policy which covers contract works. And what is anticipated is that there will be damage during the course of the works. That is why the cover is obtained, and that is the harm which is insured against. And it's only for that. Other arrangements might need to be made for anything that happens thereafter, once the project has not only achieved practical completion, but also the one-year maintenance period has expired. That will then be a matter for the building owner to make its own arrangements for. But so far as this is concerned...
but the argument against you is that if you're right on your interpretation of this policy, the building owner couldn't make such arrangements after the event.
Well, that might only, and I say might, but I think perhaps what you have in mind there, my lord, is the fire example. That is not, in my submission, a basis on which to construe the policy.
It isn't the fire example. We saw in Mr. Justice Butcher's discussion, there was another case, and I'm sorry, my brain's just went to mush at some point, but there was another older case where the lack of ability to reinsure after was also part of the court's reasoning as to what the policy meant. And what I'm just testing with you is that, as I understand it, the point was being put to you that if you're right, it's in fact that the building owner will not be capable of making any arrangements after the expiry of this policy.
Well, but as I say, we submit that is something which these sophisticated parties must be taken to have taken into account. And this was the scope of the cover which was procured. We submit that what one then has to do is look at the risk allocation which is contained within the language of the policy itself and the structure of the policy itself. And we submit that that makes it plain that what was undertaken by insurers did not go beyond cover for damage which occurred during the period of insurance. Now, my lords, with that, I wonder whether perhaps I might just turn on to the subject of developing damage in a little bit more detail. We submit that what was explored yesterday as the normal principles of the assessment of damages, we submit that they are subject to the parties' bargain.
Are we still talking about, are you still summarising your position?
Yes.
Yes.
My lord, given the amount of ground that we covered yesterday, I just thought it might be sensible simply to draw together what our position is so that you have our submissions in one.
No, forgive me, I just wasn't sure because you said you were going to deal with something in more detail. I didn't know if we stopped summarising.
It's summarising the position in relation to development and a little bit more detail on that. Forgive me. Now, we submit that those general principles which were explored yesterday in relation to the assessment of damages are subject to the parties' bargain, that damages payable with the full cost of repairing, reinstating or replacing property loss in accordance with, or damaged in accordance with the basis of settlement. And of course the reference to property loss or damaged is a reference to insured property. In other words, it's damage in relation to property where the damage occurs within the period of insurance, and it doesn't include further damage outside that period. We submit that additional damage is outside the scope of the insurer's promise, and therefore it's outside the scope of any breach. Now, I wonder with that if I can come on to this question of knife and faith, Rossa and the Marinos. Now, following on from the point that was very helpfully made by Lord Justice Snowden and Lord Justice Popplewell,
I sense some inverted commas in that.
Yes.
Well, helpful in this sense, because, of course, I think what was being adverted to was a certain tension between those paragraph references and other dicta elsewhere in WASA. And it's as well to try to address it. Perhaps I can try. Well, it's worth pointing out, perhaps, that Lord Sumption, of course, appeared in WASA, and he gave the leading judgment in Renos. So perhaps the first point to make is that you have at least one individual there who would have been very familiar with the arguments in both. Next, I think what was being suggested yesterday is that Lord Mance treats Knight and Faith as if it was a case in which the insured peril had to occur within the period of insurance, as opposed to damage, and that provided the explanation as to why it was at paragraph 39 he interpreted Knight and Faith as being authority for the proposition that if you have the insured peril within the period of insurance, then developing damage and so forth would be covered. That was paragraph 39. We can go back to it if we need to do. But that, as I understand it, was what was being suggested in relation to paragraph 39. Now, I think the point then being made by Lord Justice Snowden was, well, if Lord Sumption at paragraph 10 in the Renos decides that it's paragraph 39 that he's going to refer to in the connection with Knight and Faith, paragraph 39 from WASA, then Lord Sumption also appears to be treating Knight and Faith as a case in which what had to occur during the period of insurance was the insured peril and not damage. And if that's right, and if Lord Vance is saying that developing damage falls for indemnity, contrary to the submissions that I made yesterday as a matter of construing what was being said, but if what Lord Vance is saying is that developing damage falls for indemnity in circumstances where the insured peril has occurred within the period of insurance, then we would submit that that is not authority for the proposition that developing damage is covered where the insured event which has to occur within the period of insurance is damage itself. And in those circumstances, all the general propositions which we looked at yesterday in WASA and elsewhere hold good.
What's the difference between insured peril as a causative risk and insured peril as the occasion of damage? Why should there be a distinction?
But what seems to be the position at paragraph 39? Perhaps we can just go to paragraph 39 of WASA. My Lord, you'll find that behind tab 44. And it's page 1098. Now, at paragraph 39, he quotes from Knight and Faith. And you'll remember, my Lord, I think we had an exchange yesterday where I was suggesting that what Knight and Faith was talking about was damage occurring during the period. And there was a suggestion, I think, that perhaps it might be the peril that had to occur during the period. And if we read on into the brackets, the parentheses, after the reference to Knight and Faith.
I mean, it's clear we're all agreed that in the third line, the word period is wrong, and it should say...
That's your period, yes, absolutely. Yeah. And I think Ms. Red read it in that way as well, very helpfully, on Tuesday. Now, in parentheses, the emphasis in that case is on the need for the peril insured against to occur during the continuance of the risk. Damage materialising or developing from it after the policy period would still be covered. Now, my submission is, if that was a policy in which the insured event was the occurrence of the peril, remember, I started my submissions on this aspect. I invited your attention to Coninfo and drew attention to the fact that it distinguished between policies which require damage to occur during the period of insurance and those which require the insured peril to occur. Here, Lord Mance appears to be treating the Knight and Faith as a case in which what had to occur was the peril. And if what he's then saying is that is authority for the proposition that you can recover damage which materialises after the period of insurance, provided the peril occurs, then my submission would be that does not bear on our case and is not authority for the proposition that under this policy, the insured is entitled to recover in respect of developing damage, because in our policy, in contradistinction to how Lord Mance takes Knight and Faith, what has to occur within the policy period is the damage itself, and it's only damage occurring within the policy period which falls for indemnity.
So when Lord Mance raises as something that may be contemplated the disposal or leakage of waste causing spreading contamination over a period, which does seem to contemplate development damage in the sense we're concerned with.
Yes.
He's raising that. Why?
Well, of course, the background to WASA was the American decision and the difference in approach, which was common ground as a matter of English law and as a matter of the law of Pennsylvania. He was considering developing damage in the context of the background facts of WASA. As we know, is developing contamination over 30-odd years at 58 sites. But here, when he cites Night and Faith, I started, as you know, by saying Night and Faith is a case not about developing damage, but about ascertainment. We then looked at this paragraph, and the point was made, well, the language here, developing damage, doesn't sound like ascertainment, and the point was also made in connection with paragraph 10 of Renos, where Lord Sumption refers to it. The same point was made. And the submission, therefore, is the starting point for Lord Mance in his analysis, which is referred to by Lord Sumption, is that WASA is being treated, Night and Faith is being treated as a case that requires the peril to occur within the period of insurance, not the damage. Now, if that's right, and from then on you get the developing damage afterwards, that doesn't affect our case, because ours is a policy which is different in kind, and the material distinction is the damage and all of the damage has to occur within the period of insurance, not the peril insured against, contrasted with the understanding, or at least the approach to Night and Faith taken here by Lord Mance.
But when Lord Mance talks about this being a basic principle of English property insurance law, what do you mean by that?
Well,
I understood that we are dealing, in this case, as indeed he was, with property insurance.
Well, it is, that there is a curiosity, and I think that Lord Justice Snowden has referred to it on various occasions here. The position in relation, on the facts of WASA, the position that the court was concerned with was the question of developing damage and a policy which provided cover for damage occurring within a period of insurance. This particular comment in relation to Night and Faith appears to be addressing a different situation where, on the face of it, Lord Mance is treating the peril as being something which has to occur within the period of insurance. And in my submission, if that's right, that provides the explanation for why he says that developing damage might be recoverable. And that would be consistent then with Lord Sumption referring to paragraph 39, because it must be the case that he too was considering a situation where it's the peril that has to occur. Lord Sumption, having appeared in WASA, would be very familiar with the fact that every law lord went out of his way to stress the fundamental principle of English law. In a damage occurring policy, you can only recover the damage that occurs.
The difficulty with that submission is that he uses the expression damage materialising or developing from it after the policy. So he's contemplating both possibilities.
Well,
A, it doesn't arise at all until after the policy period in which the risk is attached, or it does arise to some extent, but develops thereafter.
But the critical
that's what the language says.
It is, but the critical, my lord, that's right. But the critical feature, nevertheless, going back to where I started, with the requirement for the insured event to occur within the period of insurance, what Lord Mance is doing here is treating the insured event as the peril. Now, it may be that damage is coincident with it. It may be that damage develops thereafter. But what's required to trigger cover, what has to occur within the period of insurance, on this analysis and this approach to Night and Faith, is the peril. And it's for that reason that on this approach, you might be able to recover developing damage.
But in paragraph 38, which Lord Mance, it precedes this, and it's this construction of the slip, he's dealing, as you can see, just above F, in paragraph 38,
Yes.
with a slip which, it says the only property damage which the reinsurance constituted according to English law principles covers is property damage occurring during the 3-year reinsurance period. He's talking about precisely the same sort of property insurance that we are dealing with in our instant cases. And he then goes on to make a comment.
Well, my lord, paragraph 38, he is dealing with that, and the comments that he makes elsewhere in his speech, and indeed the speeches of all the other law lords, are, in my submission, entirely consistent with our opposition namely that damage outside the period of insurance isn't recoverable. The departure from that occurs and occurs only at paragraph 39 and only in the reference to no item face. Because, of course, as we know and as we saw yesterday, if you go over the page to 1099, he comes back to the general proposition that's set out by Lord Justice Hobhouse, which I relied upon yesterday for the proposition that damage occurring outside the period of insurance isn't covered.
Can I raise just one more point on this to have your comment on? Lord Mance obviously thinks it's relevant to what has to be decided in this case to address this question. And if it is him addressing what happens when you have damage during the period of cover, which develops thereafter, then one might say, well, why is he addressing that question? And the answer may be that because of the way that, as we've seen, the question of damage after the policy arises in a slightly unclear way as to whether it's treated as being within the arena. He's doing it to make clear that when what is said elsewhere in the case about damage occurring both before and after the relevant policies in this case, is talking about distinct damage, not developing damage. And for that reason, he's mentioning here that, of course, there is a principle that you do get developing damage, but although one might contemplate the disposal or leakage of waste causing spreading contamination over a period, that's not what he thought he was concerned with in the case in front of him.
My Lord.
Is that one explanation?
I think to give a full answer to that, I would need to go back and trace through all the references in WASA to precisely how Lord Mance addresses the question of the damage on the facts in WASA. But my initial answer, and perhaps I can give that, and perhaps I can come back to that in reply,
Yes.
Because it's obviously something that's concerning your Lordship. My initial answer to that is no, because WASA is plainly a case of continuing damage over a period of 30 years, and the premise or the parameters within which the WASA case operates is the fact that the American court said that you can recover for all of that damage before, during and after, provided some of the damage occurs within the period of insurance. The five law lords say in the most emphatic terms that that is not the law of England and that you can only recover the damage that occurs within the period.
There was clearly continuing damage over the period, but the distinction that matters for our purposes is whether in any particular period there was damage which was independently caused, albeit a continuation, or whether it was itself the result of previous damage. And that may be what Lord Mance was focusing quite carefully on in this paragraph.
Lord, all I can say
all I'm
at this stage,
suggesting.
I think, to give it a clear answer, or perhaps a candid answer to your Lordship's question, is that without going back to the case just to test quite how Lord Mance understood the character of the damage in WASA, then I think any answer that I gave you now would risk being inaccurate, or at least ill-considered, and apt, I hope, or apt possibly to mislead, and I certainly don't want to do that.
Well,
but I wonder if I can come
feel
back
free to take that opportunity at any stage before you've finished, but I thought I would raise it because obviously it's something in my mind.
Lord, that's extremely helpful, and in reply, I will address that.
Can I ask this, though? One thing that troubles me about some of the terminology here about developing damage and saying that it develops after the period of insurance. Well, it may be that the deleterious effect of the pollutant does not actually cause the damage until later. But I query whether that doesn't mean that means that the damage didn't occur at the outset. I mean, let's give you the example.
Yeah.
Take, for example, you have a large container, cargo of, say, water, and an amount of pollutant is inserted into the water. The moment it's inserted, it's only contaminated a very small amount of that large cargo. But you know that it is inevitably going to spread. And the moment that pollutant has gone into The water, you know the damage has been caused, even though 99.99% of the cargo at that point is not actually damaged. So the inevitable development, spread of the damage is all reparable back immediately. You say at that point that cargo is worthless. So why does development mean that the damage is only caused after the period of insurance?
Well, the preliminary point would be we looked at risk minimisation yesterday. I don't want to repeat that submission. But it may be that the answer to your Lordship's question, at least in part, depend upon the nature of the damage here. Your Lordships know that in order for decay even to start, there has to be a moisture content above 25%. And if the moisture content then reduces over time to below 20%, decay stops. Now, the answer to my Lord's question is bound up with grounds 1 and 2 of insurer's appeal, which is to do with the nature of damage.
Yes.
Because I think, or I would submit that although I understand the example that Miller has just given, in my submission it's not apposite to capture the nature of the damage and how it occurs in this case. And what we would submit, and I'll come on to this in more detail in ground 1, we submit that the relevant damage which has to occur in this case has to be damage which so impairs the structural integrity or strength of the wood that it requires repair or replacement. And the reason why that is the case is, first of all, that's what's provided for on the basis of secondary laws. But secondly, it's what it is that Sky is claiming for. Sky is not claiming to clean off mould from timber. It's not claiming the cost of drying out, because all the drying out costs have been incurred. They were incurred by Prater some time ago. We know that the drying out works finished in 2018-19. The subject matter of this claim is repair and replacement. And we know that the Mace scheme approaches this on the basis that all 472, we say indifferently or indiscriminately, but for all 472 will need to be repaired or replaced. Now, in contradistinction to the sort of example
just pausing, you'll come on to it perhaps when you do your grounds 1 and 2. So you say that sodden and slumped mineral wool insulation is not damage.
No, not as broadly as that. What I say is that is not damage which is relevant to the claim that's being brought. When we come on to the question of what is damage, which are our grounds 1 and 2, the way in which we put it on, there are two limbs to the argument. We address the question of damage more generally in the abstract, limb 1 of our argument. Limb 2 is to look at what we say is relevant damage for the purpose of this claim, because that's all that your Lordships need to be concerned with. If what's being claimed for is the cost of repair, then a minor bit of wetting on one cassette in a distant part of the building plainly would not justify that remedy. That's our point.
But on the judge's finding, which
yes.
is on the basis, I think at the moment we're proceeding on the basis of the judge's
yes.
view that water is damaged.
Yes. Well, water only of a certain character. The judge was quite careful, my lord, to say only that water which, if left unattended,
yes.
would lead to damage. Now, I say that's too broad.
Yes.
But what that's contemplating is water above 25% moisture content, because otherwise it can't cause damage.
But once you, on that hypothesis, subject to your plans of appeal,
yes.
once you have that, which is effectively a pollutant in the cassettes, why at that point have the cassettes not been damaged in a way which will lead to deterioration?
But look, this perhaps goes to, and it's a very helpful example, the example that your Lordship gave of contamination of water and so forth. That is an example which appears on its face at least, and forgive me if I've misunderstood, but an example of commingling. Something gets into a liquid or water, and then because it's commingled, essentially you have to treat the whole as needing something being done to it. It's quite different from this case. There are 472 separate cassettes. I think the description that was referred to yesterday was hermetically sealed. Now, damage in this case has occurred at different times and in different cassettes and in different bits of the cassettes over really quite a long period of time, over a period of years. And that reflects the fact, and you'll have seen it in the judgment, the judge explains that these cassettes were installed on the roof at different times, in different zones. We can't be quite sure when it was.
But nobody's suggesting here that we're looking at water ingress after the period of insurance.
The ingress
water ingress prior to the end of the period of insurance.
On the judge's analysis, the damage which he regards as being insured was damage that was caused by water that got in during the period of insurance. But our submission is that of itself isn't damage.
I'm not sure then why the number of cassettes matters, because when each cassette that has been damaged by the ingress of water in the period of insurance.
But built into your Lordship's question, I think, might be certain assumptions about what constitutes damage. And I'll be making some submissions as to whether or not water getting in of itself is damage, some submissions as to the water to which the judge refers, which is water which if left unattended will cause damage or decay, and whether either of those are in fact relevant for the purpose of this claim, which is a claim for repair and
I'm
replacement.
struggling with this because the whole concept we're talking about here, which is developing damage, is based on the premise that there is damage during the period of insurance to the relevant cassette. So what we're talking about is whether or not, if that develops after the period of insurance, is that not physical damage within the period of insurance?
Well, my Lord, that I think goes back to a point I made very early on, and forgive me, but I think I started when looking at questions of damage by making the point that what is described as deterioration or development is in fact additional damage. It's damage which
but it's caused by the ingress during the period of insurance, which led to physical damage.
But of course, that is to identify a cause. What has to occur within the period of insurance in this case is not a cause; it's the damage that has to occur. And
but why? Forgive me. Why is it different in principle? Why does the water continuing to do its work after the period of insurance not the same as the pollutant in the large pool of water gradually, by Brownian motion, if that's the right term, moving throughout the whole big vat of water? Now, I appreciate there may be a difference in the sense that once the pollutant's in the water, there's nothing you can do about it, or probably nothing you can do about it. There may be things you can do to stop the spread, development of this water damage, but that, one might say, is then a matter of mitigation.
Well, I think it might again come back to the character of these cassettes, at least in part. Going back to the hermetically sealed point, I think Mr. Edwards accepted on Tuesday, forgive me if I'm wrong about it, I'll be told if I'm wrong about it, but my understanding at least was that what was said was you might get additional damage within cassettes, but what this was not a case about was, as it were, transmigration between cassettes. It's not a case where water is spreading throughout the whole of the roof.
We're talking about cassette by cassette.
So cassette by cassette. Our position so far as damage is concerned would be this, that it isn't a case just where water gets in and at that point you're entitled to say, well, that is damaged, at least not relevant damage for the purpose of this claim. Decay only takes place once a particular moisture content has been achieved and once the water has stayed at that level for a period of time. 12 to 18 months is decay, which we would say starts to affect the structural integrity of the timbers. So what you really have, rather than the commingling exercise which was contemplated by my Lord's example, what you really have is a situation of little patches here and there, a bit of decay here, a bit of decay develops here, a bit of decay develops there. In my submission, factually, it's strikingly different from the sort of example of commingling, where you only have to get a little bit of some pollutant in the water or whatever the liquid might be, and for all intents and purposes, then the whole is affected. That's not this case. And one of the reasons it isn't is that water itself, as Mr. Coulson set out at some length in his reports, and I think was accepted by the judge, we'll come through it when we look at the judge's judgment. If all you've got is water, all you have to do is dry it out. Mr. Coulson was asked in cross-examination, suppose the water's been in there for 6 months, you'd expect that to be damaged, wouldn't you? And his answer was, no, there'll be no damage to the timber at all. All you have to do is to dry it out. And so it's quite different from the example that was being posited, I think.
Okay, it may be that it's just I haven't grasped the facts right from the start. But my understanding is that water got into, let's just take a cassette.
Yes.
Water got into the cassette during the period of insurance. At the end of the period of insurance, it was still there.
Yes.
As I understood it, the one thing that happens as soon as water gets into a cassette is it's absorbed by the mineral wool insulation, which slumps. Yeah?
Over time, but yes. Yes.
Okay, but it starts,
yeah.
And that of itself renders that mineral wool insulation not fit for the purpose for which it's designed, because it no longer has the insulation characteristics.
That's the case, yes.
So,
or the case is put.
I know you're focusing on the wood, but let's just think about mineral wool insulation,
yes.
which is an integral part of this cassette.
Yeah.
That would be damaged. That is, do you say that's damaged?
Well,
when it's become sodden and slumped at the period of what period of insurance?
What would have to be demonstrated is that its thermal properties have been compromised. Now, as I understand it, I don't think there was any evidence led as to thermal properties being
blindingly obvious.
Well, I was going to say, but you might think it as being, let's assume against me that that's blindingly obvious. The position we would say there is, even if that constitutes damage, which needs to be addressed, there is no claim for the cost of insulation. The claim that is being advanced is a claim for the replacement or repair of the entire cassettes and of the wood. And so what one has to look at is not what happens to the insulation.
But let's just move forward. As I understood it then, there were two different types of wood in the cassette. One is the OSB on the top, and the other one is the softwood frame,
yes.
for want of a better expression. So my understanding is if you leave the water after the end of the period of insurance in the cassette for a period,
yes.
At some point the OSB will start to swell,
yes.
and be damaged,
yes.
and itself become unusable.
Yes.
So if you haven't dried it out by that time,
yes.
that's damage which in the ordinary course of events will occur.
Yes.
If you do dry it out in time,
yeah.
you might be able to stop the OSB swelling,
yeah.
if you like.
Yeah.
Okay? And then if you leave the moisture in the cassette for longer still, not only will the OSB swell, but actually you start getting decay in the softwood.
Yes.
Right. You can arrest those latter two processes in relation to the OSB and the wood by a drying out process at an earlier stage.
Yes.
Have I got it so far?
Yes.
Right. So I thought the question was, if after the period of insurance expires, there's still water there, you then have the inevitable capacity for that water to create one or other of the swelling of the OSB or the deterioration of the wood. So at that stage, if you ask the question, what's the damage? Why don't you say, well, the whole thing is damaged because if left unattended, one of those two things will happen.
And what you would need to do to repair that damage, or to treat that damage, is dry it out. And that's what, in fact, was done. And you know there was a partially successful drying out in 2015-16, but a wholly successful drying out in 2018-19. And it's the claimant's case that was successful.
But it may have dried it out, but it may not have prevented the...
Yeah. In which case, the question then becomes, to what extent had it not prevented decay from occurring as of 2017? And that's precisely the exercise which Mr. Coulson undertook, and which the judge said was the best analysis and the best evidence, subject to his qualifications about Mr. Coulson adopting an impermissibly narrow test, and that's the subject of our grounds 1 and 2, which I'll come on to a little bit later. But that's precisely the exercise that was done, because what he did was to look at the photographs in 2018, extrapolate back, and it needs to be, I can show you Mr. Coulson's CV. He has a wealth of experience, you've probably seen it. And he was then able to say that as of 2017, the wood in question, particularly the timbers in question, he was able to identify whether or not they would have required repair or replacement. So in other words, one's looking then at 2017 and saying, and answering Lord Justice Snowden's question, has in fact damage occurred? Had the water progressed to that stage where you've got decay that needs to be treated? That is the exercise that Mr. Coulson did.
But I think my Lord was putting to you essentially the question, and I may have got this wrong, but why isn't a cassette which has water in it at the end of the period of insurance damaged?
Well, on the judge, let's assume for a moment that the judge's test is right. On the judge's test is right, it would be damaged because there is water in there which is capable, if left unattended, of leading to structural decay.
Yeah.
Now, what that isn't, though, as of 2017, is structural decay. The remedy for that, the repair of that damage, if damage it is, as at the end of the period of insurance, is simply drying out. The presence of water, which might lead to possibly a small little bit of decay in a part of the cassette, is not, even if damage which could be said, we submit, to justify the replacement of a cassette. All you would need to do is dry it out.
But why is it not damaged to the extent of the decay which will be incurred before it's possible to successfully dry it out?
Well, built into the question, my Lord, is the fact that the decay hasn't occurred. The remedy that's required, if wetting...
No, just like the drop of toxin hasn't polluted the whole of the water, but it's going to.
Well, but the remedy, the base of settlement is repair, replacement, reinstatement. What you need to do to reinstate the position there, if all that has happened is progress to the point that your Lordship contemplates it.
That's a matter of reasonable mitigation, isn't it?
But it's a matter of assessment. Because what you need in order to repair or reinstate,
maybe.
Well, that comes on to the, as I say, in our submissions we have two limbs in relation to damage.
I thought you were not saying that there had been a failure to properly deal with the water ingress. It's not your case that they should have dried out more successfully sooner.
It doesn't depend on that. What it depends on is assessment of what was the position as at 2017.
Well, that's your submission as the ultimate outcome. But my concern is, why, when you look at the position in 2018, why do you have to take it back? Why does one not say, this is the decay which has resulted from the water as of 2018, 2019, and that was inherent in the damage at the end of the period of insurance? If you want to say, no, it should have been dried out sooner, so that decay should not have happened, that would be another argument, but you're not saying that.
My Lord, I don't think I need to say that. But when you say the damage which is inherent in a sense, that raises questions as well as answering a point. What's meant by damage being inherent in some sense?
Well, it's going to happen because of the damage, unless you dry it out.
The damage has to happen.
But your case is simply
It's not occurred.
not covered. The policy is only the damage that's occurred prior to the
And can I explain the distinction? If one takes the judge's analysis, let's assume that his definition of damage is right for a moment. What you would get by way of addressing that is the cost of drying out. That's precisely what was done. Prater did all the drying out works, and we know that it's the claimant's case, and the judge found that drying out work was successful, and it arrested any process of decay. What we're concerned with, we submit, is relevant damage which will justify a claim for £196 million for repairing or replacing every single cassette. And we submit that the only form of damage which justifies that is damage which impairs the structural integrity of the cassettes, such that they need repair or replacement, and that has to occur by the end of the period of insurance for the insured to recover under this policy. And it doesn't matter whether water is there, if it has not led to that level of structural decay, as at 2017, then all that you would be able to recover would be the cost of drying out, because that's the remedy that's needed for what it is that's occurred up to that point in time.
Oh, so there would be insured damage in that?
Well, my Lord, that's...
Or is this all subject to your other ground?
Well, we have a primary ground,
Yes.
And I'll come to that in due course, and then a secondary one.
Yes, and this is on the assumption the judge was right about.
Yeah, this is the assumption the judge is right. Yes. And just so that your lordships know what I'm hoping to do later on, that's going to be to focus upon the second limb of our argument, because in our submission it's absolutely critical that one looks at this from the point of view of the remedy that's being sought. To take a very simple example, take the Ordula, which we'll come to in a moment. That's the case about hydrochloric acid being spilt on the deck of the ship. And Mr. Justice Mance said that was damage. It was relevant damage. The reason why it was relevant damage is because the claim was for clearing the deck. It's for wiping off the hydrochloric acid. Had the claim been for the structural dismantling of the deck and its replacement, then plainly there wouldn't have been relevant damage to justify that remedy. It was only regarded as damage because what was being claimed was the cost of wiping up, and the fact that you had to get rid of it and you had to expend money in order to do so was for those purposes regarded as relevant damage. That's a very different situation from ours, where what it is that's being claimed is a very large sum of money for structural replacement, and we submit just as mould wouldn't support a claim for structural replacement, so too merely having water in there, either water which is below 25% and then won't lead to damage anyway, or even if it's above 25% and might at some time, 1 year, 2 years, 3 years, who knows, at some later stage lead to damage, that also, as of the end of the period of insurance, would not justify the remedy of repair or replacement, because all that would be required to put it right is to dry out.
I mean, we're going to get onto this, so I'll sort of just put my marker down for a second, but I find it difficult to understand how you define damage by reference to the remedy sought. I mean, for example, wiping the deck of hydrochloric acid, you're not doing it because you're doing it because you can't walk on it or use it if the deck is covered with hydrochloric acid. It's got nothing to do with structural integrity. It's that you can't use it for the purpose for which it's
precisely
there.
Yeah.
You'll get onto this, but even if the structural integrity of the cassette is not affected, if it's got water in it, isn't its functional performance affected? Well, why not?
Its functional performance, structural performance, isn't affected until you have significant structural.
Well, I know it's structural. You say structural might not be where you define it.
No.
If you have a cassette which is absolutely full of water,
Yes.
first of all, the insulation won't work.
Yeah.
It won't work thermally. It'll weigh an absolute ton.
Yeah.
And I, for one, wouldn't want to be working under a biggest wooden roof in Europe, which is completely full to the brim with water.
Yeah.
So functionally,
Yes.
structurally, you may say, hey, the wood's still there to support it, but its functionally isn't doing what it should be doing.
So, my lord, on that analysis, I can quite see that there you might say, oh, well, there's damage. Let's say that just for the purpose of the discussion, assume that that's right, that constitutes damage. That, on one view, might be what the judge has found, with the qualification that it would, if left unattended, lead to structural decay. Just assume, for the purpose of your lordship's example, if that's correct, that would not justify structural repair and replacement. What that would justify is getting the water out. But nobody's claiming for the cost of getting the water out.
Right, okay.
Right. We've taken you slightly out of the course because we've taken you into the ground you haven't yet really approached, which is what constitutes damage in the first place.
Could I?
It's a little unkind because it's meant you've had to cover.
But
can I just before just before you go back to your summary, if that's where you want to go back to, can I just ask you about WASA?
Yeah.
Could you or somebody tell me where we can identify, either in the Supreme Court report or it may be in the underlying reports, what the nature of the pollution or environmental damage was in that case?
Yes. We'll do that.
Thank you.
Look, just on the point you've made, it's actually a very fair way of doing it, because to some extent, the questions in ground 1 and 2 and this question are linked, at least on the facts. So, but my lord, it's helpful to be able to address those at the same time. Can I just go back to the summary, then I'll come on to the appeals on the facts. As we understood the position yesterday, what was think being suggested to me, can I just give you this as a matter of submission so you know what our position is? What was really being suggested to me was, I think, something along these lines. First of all, the insured recovers damages caused by the breach, in other words, the failure to prevent damage during the period of insurance. And there are then various categories of damage which it might be suggested would flow from the breach. And as I understood it, there were broadly 4 kinds of damage. The first was the cost of repair occurring during the period of insurance. The second was access damage to enable the repair of damage which has occurred during the period of insurance. The third is physical damage which develops or occurs, and so it's said, as a result of damage occurring within the period of insurance. I think that was one of the examples that was given. I think I challenged the idea that damage develops from damage. Both lots of damage are different. I think in my submission I made, they might both be attributable to the water getting in, but one bit of damage doesn't infect another bit of timber, so that damage causes damage. That's not how it works. But that was at least my gloss on it. But the proposition that was being put was number 3, physical damage, which develops as a result, so to say, of damage that occurs during the period of insurance. And then finally, financial losses, such as investigation costs or professional fees. Now, our answer in relation to those categories is as follows. Sky is entitled to indemnity in respect of 1 and 2, and it's also entitled to indemnity in respect of professional fees, but nothing more, because of the extension that's contained in Memorandum 2. And we submit that the principled reason for treating these categories of damages differently is that the parties have, by their contract, agreed that insurers would only be liable for the first 2 categories and professional fees as a matter of construction of the policy. They are the only costs which constitute the cost of repair of damage occurring within the period of insurance, and therefore we submit the only costs that fall within the basis of settlement and fall for indemnity. Now, my Lord, that's our case, and that's where we get to on what I think were the various possibilities that were canvassed during the discussion yesterday. Now, my Lord, with that, I wonder whether perhaps I can change tack entirely and look at a different aspect of the appeal, and that is the very largely factual appeals which make up grounds 5, 7, 8 and 9. And what I was going to do, with your Lordship's permission, was just very briefly make 1 or 2 observations on the relevant authorities relating to factual appeal. And would you forgive me if all I do is give you references and a very short statement as to what the proposition is that I derive from the case?
Most of this is pretty familiar territory.
It's pretty familiar territory to all of you, I know. But can I just remind you just 1 or 2 of the points?
Yes.
So the first case is Wheeldon Brothers. It's in the bundle at tab 56, page 1414. It's concerned with appeals from the TCC. The relevant paragraphs are 12 to 14, at pages 1417 to 1418. And what that is authority for is the proposition that the Court of Appeal will not readily enter upon an inquiry into findings by a TCC judge or proceedings in the TCC. And the reason why that's relevant is in his order dated the 11th of August 2022, which you'll find in Supplemental Bundle A, tab 3, page 17 at paragraph 1, the judge ordered that the case should be tried by a commercial court judge with experience of TCC work.
Well, I don't think there's a special rule as to what the law is for interfering with findings of fact in the TCC and interfering with findings of fact in any lower court. But insofar as TCC cases tend to involve more complicated factual questions.
In fact, I think Lord Justice Coulson in Wheeldon Brothers makes the point that the same point could be applied across specialist courts more generally. Yes. But in this case, it's TCC. Now, Lord, the next case is Sprint Room. That is at tab 57, page 1427. And can I just really give you a series of either quotations or general propositions from the case? First of all, there is a generous ambit within which reasonable disagreement is possible. Second, authority at the highest level has warned appeal courts against interfering with findings of fact, which included evaluations drawn from those facts and inferences drawn from them. That's page 1428. And what is guarded against is this. It said that the appeal court should not carry out a fresh balancing exercise, but should ask rather whether the question was wrong by reason of some identifiable flaw in the treatment of the question to be decided. That's page 1428 as well. That includes evaluative decisions.
Can't be 1428. 1428 is the head note.
Well, I think that may well be included in the head note, but my Lord, I'll check that. Then at paragraph 71, there's reference to evaluative decisions as well as findings of fact. And at paragraph 72, the point is made that it's very difficult for appellate courts to put themselves in the same position as the judge. And at paragraph 74, we get the quotation from Henderson and Foxworth, namely that the judge must have gone plainly wrong before the Court of Appeal would interfere. And then at 77, it's perhaps just worth noting the reference to the decision of the House of Lords in Biogen, and that is Lord Hoffman's judgment about the nature of judging, the nature of judgments. And amongst other things, what he says is this, that it's inherently an incomplete statement of the impression which was made upon the judge by the primary evidence. His express findings are always surrounded by a penumbra of imprecision as to emphasis, relative weight, minor qualification, and nuance. And paragraph 78 of that judgment cites Farge, and it makes the point that there is, of course, during any trial, that I know it's very well-known stuff, there is a sea of evidence, and all that a Court of Appeal is taken to are islands of that evidence, and all you can do is hop from one to the other at the invitation of the parties. In my submission, that's precisely what has happened in this case. You've seen a little bit of an expert's report here, a sentence from a statement there. The judge had the benefit of 5 weeks of trial, 14 days of evidence, I think 16 experts, 10, 12 factual witnesses, whatever the number was. There was an enormous body of information that he had to assimilate, and of which he had the benefit, which simply isn't open to this court, either because there is no oral evidence or simply the constraints of time and practicality mean that you simply can't see the amount of information that was available to him. And then the final point from this case is paragraph 85. It is simply not possible for a judge to express a view on everything. And then the final authority that I just invite your attention to is Volpe and Volpe. Again, I know it's extremely well known to this constitution. It's at tab 73, page 1939. It's an appeal on a pure question of fact. And the point that I get out of that is this, that the appeal court is bound, unless there are compelling reasons to the contrary, to assume that the trial judge has taken the whole of the evidence into consideration. The mere fact that a judge does not mention a specific piece of evidence doesn't mean that he's overlooked it. And there's also the caveat and the warning that reasons for judgments will always be capable of being better expressed, and the appeal should not subject a judgment to narrow textual analysis. And my lords, of course, what lies at the heart of all of those authorities is the need for a certain degree of pragmatism and common sense, and an appreciation that judgments, like so many other things, belong to the art of the possible. My lord, with that, what I wanted to do was to go through the judgment pretty quickly, giving you the references, but taking you through the stages of the judge's reasoning to show how it was that he came to the conclusion that in all the circumstances, and doing the best that he could in those circumstances, that he found that the 2018-19 scheme best approximated to the scheme that was required to repair damage as at the end of the period of insurance. Now, he carried out, and he says he carried out, a detailed and careful analysis, and at paragraphs 111 to 112, he makes the point that he heard extensive witness and expert evidence. As I mentioned, he in fact heard oral evidence from 14 witnesses, 6 witness statements were admitted evidence, and he had oral evidence from 16 experts in a trial which included 14 days of oral evidence. But that extensive evidence which he heard didn't include contemporaneous evidence of the condition of the roof at the expiry of the period of insurance. And that's the point he makes at paragraphs 119 and 224. And he also notes that that would have been helpful. Then, at paragraph 224, these are how the reasoning works, he says that most, if not all, of the enormous evidential difficulty and uncertainty that permeates this case would have been avoided had the survey been conducted. As a result of that, he makes the point at paragraph 120 that identification of damage depended upon expert evidence. Now, the claimant, as you know, relied upon RAG plans prepared under the guidance of Mr. Smith. He makes that point at 121. Mr. Smith was a historic building surveyor with about 2.5 years' experience when he was first instructed, 5 years' experience by the date of the crime. That's paragraph 131. Now, although the judge rejected insurer's challenge to Mr. Smith on the grounds of admissibility, he did accept at paragraph 133 that he had, as the judge put it, limited experience and arguably very limited experience, which might mean that only limited weight could be given to his evidence. Now, I'll come on to make a submission a little bit later on, but it's this, that although what was presented to you on Tuesday, I think, were references to Mr. Smith, as if those are matters that could be accepted, on the basis of what the judge found about the very limited nature and assistance to be derived from Mr. Smith's evidence, this court should not proceed on the basis that anything that was said by Mr. Smith that wasn't expressly rejected by the judge was somehow accepted by it. And more than that, given what the judge said about Mr. Coulson, that at least as a matter of generality, if there was a conflict between the two, then it was the evidence of Mr. Coulson which was the more reliable. Now, that said, at paragraphs 135 to 141, he gave careful consideration to Mr. Smith's evidence, but then at 142 said that Mr. Coulson's approach was the only way of arriving at an informed opinion as to the level of likely damage at the relevant date. But he was concerned, amongst other things, about the number of photographs which were available for review. That's paragraphs 142 to 143. He considered the weight to be put on the evidence of each expert and recognised that Mr. Coulson was better qualified by reason of qualifications and experience, and also because Mr. Coulson took a preferable approach as a matter of principle. That's paragraphs 144 to 145. As a consequence of that, it was Mr. Coulson's evidence which was the best evidence of the condition of the wood in 2017. And that is paragraphs 140, 142, 144, 145, and 149. And can I just pause there just to invite your Lordship's attention, simply to give you the reference to the case of English and Emery. That's at tab 27 in the bundle. And at paragraph 73, what was said is this, that it is legitimate where there is a direct conflict of evidence for the judge to prefer the evidence of one expert to the other, simply on the ground that he was better qualified to give it, or the finding of the judge that Mr. Coulson was better qualified to give evidence on wood science. He was a wood scientist with wood science qualifications, whereas Mr. Smith wasn't. And he went. The court goes on to say in that case, or was a more authoritative witness if the judge is unable to identify any more substantial reason for choosing between them. Now, although the judge found that Mr. Coulson was to be considered generally the most probative, he didn't accept his evidence without qualification. And that is paragraphs 146 to 148. And this forms the subject matter of insurer's ground 2, which I'll come on to a little later. At paragraph 153, he rejected Sky's evidence that the roof was a total loss by the end of the period of insurance, or that there was cover for deterioration after the period of insurance. But, and it is a but, he accepted the submission that damage was more extensive than insurers accepted. And so as a result of that, he didn't accept the evidence of Mr. Coulson wholesale. And I hope that's a fair summary of how the judge put it. However, what he did then at paragraph 155 was to observe that he was left to do his best with what he referred to as the meagre material available. Now, just pausing there, this is the claimant's claim. The claimants are responsible for the material that's put before the judge in order to make good their claim for indemnity. And that material was described by the judge as meagre. He then went on to consider insurer's 2018-19 scheme, and he said that was the best evidence of the state of the roof after the drying out. And at paragraph 156, he said that despite finding that there was no additional deterioration between the end of the period of insurance at 2018-19, there was no evidence that the work identified as necessary following the drying out would be any different from that which would have been required at the end of the period of insurance. So there may have been deterioration between 2017 and 18-19. The judge found that that would have increased the scope of repairs or their cost. He then said this. He said that the reference to, or I should just point out perhaps, that where he talks there about work identified as necessary, there is a reference to work identified as necessary by Mr. Jessup, insurer's structural engineering expert, because he was the only expert who considered what work was necessary at 2018-19, and he devised the repair scheme that the judge accepted, subject to certain qualifications in relation to temporary works. Now, as a result of all that, the judge then accepted that Sky's submission that deteriorated between 2017 and 2018-19 didn't alter the remedial work required, paragraph 157, and although, of course, that was conditional on his finding that Mr. Coulson had approached the question of what constituted physical damage in what he referred to as an impermissibly narrow way. Then the result of that, I think it's fair to say, is that the judge felt as though the claimant's approach to this case had made it hard for him to assess quantum, because they'd not focused on 2017, but we submit that what they've done is put forward schemes to remedy all of the damage, either at the date of trial or beyond. And what he found at paragraph 182 is this. He found that the Sky and Mace schemes assume that all the damage suffered to date, and to be suffered hereafter, until repair and replacement can be completed, should be remedied at the cost of the defendants. Each scheme, that is Sky's and Mace's, simply does not address how I should assess the sum due to Sky under the policy as it is properly construed. And then in the next paragraph at 183, he said, doing the best he could, he was satisfied that of the various schemes discussed in the evidence, the 2018-19 scheme most closely approximates to the work necessary in order to rectify the damage suffered down to the end of the period of insurance. At paragraph 221, he noted Sky's submission that 2018-19 scheme didn't address the actual assured damage before saying this. It may be, he said, it may well be, that there is additional damage to which the policy responds on its proper construction during the period of insurance, but it's not open to Sky or Mace to complain about that in the absence of a coherent evidential case that addresses that issue. And we rely heavily upon the judge's finding that neither claimant had put forward any such coherent evidential case in relation to damage at the end of the relevant period. Now, against the background of that analysis, we submit that there is no proper basis upon which it could be suggested that the judge hadn't taken all the evidence into account, or that his conclusions in relation to the factual issues raised by grounds 5, 7, 8 and 9 were plainly wrong. To go back to well-known language, there was a sea of complex, intertwining complex, factual and expert evidence, all of which, as the judge makes plain, he considered. And in contrast to that, what Sky invites you to do, perhaps all Sky can invite you to do, is to carry out the exercise of hopping from one island of evidence to another, which they have selected for you to visit. It is a very different position which you are in to that which the judge was in, and that, of course, is one of the points that's made in the authorities that I've just mentioned. And in my submission, a court such as this is in nowhere near as good a position to assess the evidence as was the trial judge. Now, with that, as by way of general introduction, as it was a frame at the nature of these appeals and the legal framework, as well as what it is the judge found, could I then turn to the specific grounds? And I'd like to do this very quickly because I'm really quite short of time, because there's quite a lot to get through after that. I wonder if I could just come to, first of all, ground 5, deterioration. Now, As noted at Insurer's Skeleton, the decision to which Ground 5 is directed is the finding of the judge that the 2018-19 scheme most closely approximates to the work necessary in order to rectify the damage suffered down to the end of the period of insurance. That's judgment, paragraph 183. And Sky contends that it's because the judge wrongly discounted the Sky, or because of that, that the judge wrongly discounted the Sky and Mace schemes. And as a result of finding that the state of the roof is now much worse than it was than at the end of the period of insurance. That's, again, paragraph 183. And that there was severe deterioration after the expiry of the period of insurance and after the drying out works, which it's accepted would have arrested deterioration resulting from water ingress occurring down to the end of the POI. And that is set out at paragraphs 80, 88 and 90 of Sky's skeleton, and that's at core bundle A, tab 7, page 203. And what Sky contends is that that finding was inconsistent with his earlier finding of paragraph 157, that any deterioration between the 15th of July and when compartments were opened up for drying in 2018-19 would probably not alter the type, scale or cost of the remedial works required. However, we submit that it was the premise on which the proceedings were brought that Sky and Mace were claiming for all of the damage, as the judge observed, which had occurred to the trial and would occur to the completion of the remedial works, and that the extent of such damage was substantially greater than the damage as at 2017 because the nature of the damage was progressive. We submit that was the premise on which these claims were brought. And indeed, it's for that reason that ground 1 of Sky's appeal arises at all. That's why it's relevant. If that were not the position, and if Sky were not claiming for it, there'd be no reason to have ground 1 at all. Now, I wonder if I can just give you a couple of references in order to make good the submission that that really was the premise on which the claims were brought. First of all, if you would be good enough, or perhaps just make a note, please, of Sky's opening submissions appendix 2. Can I give you the reference for that? It's the supplementary bundle A, tab 5M, page 52A, and that is a table which includes a summary of the assessments carried out, and it says that the aim was to address damage to the timber structure. And I only need to just tell you what was said, you don't need to turn to it, which occurred prior to July 17, but which has developed progressively up to the present. And you'll see this when you turn to it. So what was being said was these schemes are being devised in order to address damage to the timber structure at 2017 and to address the damage which developed progressively up to the present. And, my Lord, we submit that this proposition is evident from and reflected in the claimant's pleadings, and the relevant references are given in Insurer's Skeleton, paragraph 42, and that's at core bundle A, tab 8, page 224. And in this regard, I wonder whether perhaps I can just invite you to one document to see how it was put. If you'd be good enough, please, to go to supplemental bundle A, tab 5D, page 28. And this is paragraph 139.
Supplementary D.
No, supplemental A. I'm so sorry. That's my fault.
I just probably misheard you.
No, I'm sure it's my fault. It's supplemental A, tab 5D, page 28.
This is Sky's written opening.
Written opening, paragraph 139. They're commenting on, what might say, excoriating insurers' proposed schemes. And what they say is, worse still, what insurers propose by way of remediation is hypothetical only and not even intended to be implemented. Well, that's because it was trying to assess what the position was at 2017, as the judge observed. But their proposals as to remedial work are avowedly premised not upon the condition of the roof as it stands today, that's the criticism, but on the condition of the roof as insurers allege it to have been some 5.5 years ago, or 4 years ago. the result is that even in areas currently known to have sustained damage, insurers exclude from the scope of works, and then little 2, any property that has progressively deteriorated and that Mr. Coulson considers to have crossed his threshold for damage after July 2017, any works upslope from the gutters which was identified in 2022, not of course identified as of 2017, or even related back to 2017, but the 22 opening up works. And so the criticism that's made of insurers' scheme is it does not address the position now, which is more serious than the position as of 2017. So we submit that that was the way in which the case was being brought. And then, if I could just make one further brief point in relation to this, the judge preferred the evidence of Mr. Coulson, and he rejected the 2017 scheme. He had to do the best that he had with the meagre material with which he'd been furnished by Sky. That was paragraph 155 of the judgment. And doing the best that he could, he said that it was the 2018-19 scheme which most closely approximates to the position as of 2017. And we submit that as per the skeleton, there was in fact ample evidence of damage after 2019 and justification for the evidence as it emerged over weeks for his finding that the 2018-19 scheme captured all the damage that the claimants had proved by the end of the period of insurance. Now, in our submission for all the complaints that Sky makes, if there was damage to upslope areas or beams, there was no evidence as to when that damage occurred, how much damage there was, or what it would cost to rectify. So even on Sky's own case, even if we were to accept, which we don't, because amongst other things Mr. Coulson says that the upslope areas in the 188 cassettes which were inspected, none of those in fact demonstrated or displayed signs of damage. Even if we're wrong about all of that, it still won't assist the claimants, because all the claimants can say is that was damage that was there as of 2022. What they can't tell you is whether there was any damage in those areas as of 2017, and if so, how much of it there was, or what it would cost to rectify. Now, my Lord,
when you say damage in all that submission, can you just define damage for me?
Well, our submissions to what counts as damage is that it is that level of decay which impairs the structural function
The structure.
of the cassette. Yes, the structure is, we say, the telltale or the hallmark of damage which is relevant for Sky's claim. It may be that one could say, well, if you have to dry out, that might constitute damage which would give rise to a remedy for the cost of drying out. But that is not what Sky or Mace are claiming £196 million for. They're claiming for the repair of every single cassette attended for 9 days in order to do it. And that is a claim which is for repair or replacement. And we submit that the only damage which can possibly be relevant to justify that is damage which impairs the structure of the cassette. Now, my Lord, we've set out...
It's simply because, in a sense, you're approaching it in this sequence of submissions, but actually that question of what actually constitutes damage is something you're going to come on to later, but in a sense it is logically prior to the submissions now. Logically prior to the submissions you're sort of now making.
Well, I can see why that might be said. I thought perhaps it was most convenient simply to deal with Sky's case first, but that's rather...
I'm just trying to get my bearings,
yes,
really.
No. But look, that's the point I had in mind when, I think in response to what Lord Justice Popplewell said, I said it wasn't, as it were, inconvenient to take them at the same time because to some extent they're linked. But my Lord, can I just say this? We have set out really quite detailed submissions on the areas of factual difference and made specific, all the specific criticisms that Sky has made. And they're simply just looking at the clock. There just isn't time for me to go through all those now. It would be very nice if I had the time. I just don't. but we do rely upon the detail in the skeleton. And what we say, what you get from all of that detail when you go through it, is that there is factual dispute after factual dispute. Witness saying, or expert saying one thing, expert saying the other. And we submit that the person who was best placed to assess all that evidence was the judge, and that this is really a classic example of one of those cases where this court shouldn't interfere with the judge's findings, having regard to the passage from Lord Hoffman about all matters of nuance and impression, which goes to the formation of a judge's judgment. But we submit that in circumstances such as this is not a case in which this court should interfere with the findings of the judge. As I say in the law, there are many more detailed submissions in the written submissions. There just isn't time now for me to go through those in their entirety. And it's worth just pointing out, going back to a point I made a moment ago, about the judge's assessment of what it is that had been presented to him. And it's really quite an important paragraph of his judgment, because as much as anything else, it accommodates what Sky's saying. And if I could just remind you of what he said at paragraph 221, he said this. He noted Sky's submission. Perhaps we should just go to paragraph 221. It is quite important. Page 435. He says, in reaching the conclusion that the 2018-19 scheme was the best approximation, he says, I acknowledge Sky's submission that the 2018-19 scheme does not address the actual assured damage as it is now. So he acknowledges that that's at least a submission that was made. But he says that's not a legitimate point. The reason for it is this. It was for Sky to prove what damage had been suffered down to the end of the period of insurance, but it has not attempted to do so. And this is a recurring theme of the judgment. The only attempt to do so was by the defendants, first by reference to 2017 scheme, and then the 2018-19 scheme.
I mean, at the risk of stating the obvious, all this follows from his conclusion on the first point of law about the interpretation of the policy and what damage it covers.
Yeah. And he said that, precisely, and he goes on to make the point that there was no coherent evidential case that was put to him. But my Lord, I can see that is premised on the basis of what he says the relevant damage was.
Yeah. Yeah. And I think as I said to you yesterday,
Yeah.
if in fact you're wrong on that, you could just reverse all this criticism in relation to your schemes. I mean, if you're wrong on the point of interpretation, neither of your schemes.
Certainly that changes the picture of it.
Just a little. Just a little. Yeah.
My Lord. Things are slightly different.
In terms of the detail,
Yes.
I mean, I appreciate you say you haven't got time to get into it. When we were told that there was no challenge to the proposition that 55% of lifting strop holes would result in damage, which is 1,200 compartments. And what is the answer to that?
Well, the answer to that is that if what we're talking about is the upslope areas, as I understand we are, there were 188 cassettes, as I understand it, that were investigated. Mr. Coulson was presented with the photographs of all of those cassettes, very detailed photographs from different angles, interior and so forth. And his analysis was, looking at the condition of the cassettes in 2022, as of 2017, all of those cassettes would have been in good condition. So whether, as of 2022, one could say, oh, well, there was evidence of water in certain places in the...
But he was only looking for structural damage.
Oh, that then might come back to the question of what counts down.
That's right, isn't it? He'd been told, only look for structural damage.
Yes, he was looking for that damage which would require repair or replacement. So that's the structural damage. That's
As of 2017.
As of 2017. And so what he did, it's the same exercise that he did in relation to 2018-19, which the judge held was the most probative and the best way of arriving at what the position was in 2017.
But just to be clear, even if he'd have seen structural damage in 2022 in a cassette, he might have given a nil return for that on the basis that it wouldn't have demonstrated structural damage in 2017 at the end of the period of insurance. So that may be the explanation for his zero return.
Well, what he was concerned with, your Lordship is quite right, he was concerned, and it forms the base of ground too. He was concerned in order to approach damage on the basis that it was structural damage that counted as damage. That's quite right.
And structural damage in 2017.
2017. Because that structural damage, as at the end of the period,
even if you saw on a photograph taken in 2022 structural damage, which would require replacement, he could have concluded, and probably did, that working backwards, and I think the judge, we showed us some couple of paragraphs where the judge refers to this, working backwards, he would have said in 2017.
Lord, forgive me, that's very sorry.
Well, sorry. As I understand it, even if he'd have been shown a photograph of a cassette which internally had structural damage in 2022, which would require repair or replacement, his evidence could well have been, in fact probably was, but working backwards, my expert view is that in 2017, at the end of the period of insurance, there wouldn't have been manifest any structural damage. Ergo, zero return.
In principle, given the test that he applied, one could imagine a situation where a photograph was presented to him, which might indicate that there was damage as of 2022, and he could come to the conclusion, he obviously wouldn't need to do, but he could come to the conclusion that looking at that, he would form professional view that as of 2017, it would not have suffered damage. Yes.
So he would have said, therefore, on my, when fed into the scheme, no replacement or repair or replacement required.
As of 2017.
Yeah, because that was his parameters.
Yes.
He had two major parameters.
Yes.
One is, what was it like in 2017?
Yeah.
And secondly, is it structurally damaged in 2017?
Yes.
But it follows that Mr. Coulson's evidence is not an answer to the point as it was summarised by my Lord Justice Phillips. Doesn't it?
Yeah, which is why I picked you up on it, I think.
The point that my Lord summarised is that the case against you is that it was unchallenged that there was damage in 2022 in those areas in relation to the upstairs. And you said, but Mr. Coulson says, to which I think the discussion illustrates that his evidence doesn't actually form an answer to that.
Right. to the question asked by Lord Justice Phillips, that might be right. But to look at the position there described by Lord Justice Snowden, that analysis, at least of the exercise that Mr. Coulson was doing, and you've identified quite correctly the two parameters. That's right. It's also, of course, the case that there was other evidence as well. Mr. Jessup, for the preparation of the 2018-19 scheme, he also looked at what the position was as of 2018-19, and that formed the basis for the scheme. And so that took into account not only the assessment of Mr. Coulson, but it was also the assessment of Mr. Jessup as well. What Mr. Jessup did in formulating the two schemes was that, first of all, he looked at the position as assessed by Mr. Coulson as of 2017, and then Mr. Jessup looked at the position as of 2018-19, and on that basis, he identified what the ambit of a repair scheme would be to address damage as it then was at 2018-19.
But didn't include plenums.
Plenums weren't included.
Why not?
Well, my submission on that, my Lord, is that there was scant evidence. It's in our written submissions. And if there were time, I would take you through the evidence on the plenums. We say that there was scant evidence in relation to plenums generally. Mr. Elliott, I think, wasn't even commissioned to look at plenums until 2021.
But sorry, forgive me for interrupting. When Mr. Jessup was determining what, as a matter of causation and structural engineering, was required by way of remedy,
yes,
was he taking the damage to be that as defined by Mr. Coulson?
No, he was looking at the 2018-19 photographs and coming to a conclusion as to what required repair or replacement on the basis of those photographs.
Thank you.
And, my Lord, just going back to the question of plenums, we were told that Mr. Smith was confident that there'd be damage to the plenums. As I understand it, Mr. Smith looked at two cassettes from the plenums out of the total. 5%, I think, of the total number of plenums was the basis for that judgment.
And am I right in thinking that there weren't any photographs of the plenums in 2018 and 2019?
I think very few. I think there are a few that were identified that were attached to an email, but in quite sharp contrast to the very large number of photographs that exist in relation to the cassettes generally.
Yes, so when Mr. Jessup was producing the 2018-19 scheme on the basis of the photographs he had, is this in fact the case? The plenums weren't essentially included because there were virtually no photographs of damage to the plenums.
Well, there was very little evidence, and it's worth, if I can just give you a reference, perhaps I can give you the reference. It's worth just looking at, for example, the causation experts' joint statement. Paragraph 2 of that is to be found in Supplemental Bundle E, tab 51, 847. Perhaps I don't think I need to invite you to look at it. Can I just see what it says? And
yes, tell us what it says.
At the time.
We'll go back to it if we need to.
Yeah, precisely. What it said is this. The main roof of this building was primarily formed for 428 prefabricated cassettes, and it discusses those. It then says there are further 44 prefabricated cassettes formed the roof of the higher plenum areas around each of the service cores. Less information is available regarding the condition of the plenum cassettes. Consequent to the experts' discussion has focused on the 428 cassettes that form the main roof. Now that's the causation experts, but it is an indication as to the fact that plenums were a very long way from being the main focus of this trial. And I should also say that you were, I think, referred to an email on Tuesday, which made reference to plenums. As far as we've been able to tell,
8th of June.
That's an email that didn't or wasn't referred to in any witness statement. It wasn't referred to by any expert. And as far as we can tell, it wasn't put to any witness or expert during the course of the trial. And in fact, the first mention of that witness statement was on Tuesday, that email, in the context of these proceedings. The first time any attention's been drawn to it was on Tuesday. It's fair to say that it was included within the very large number of documents that were in the chronological bundle. But in terms of anybody actually drawing attention to it, the first time attention was drawn to it was Tuesday. It certainly was not something that was drawn to the attention of the judge, and it wasn't something which was discussed with the experts. I think I'm right about that. I'll be told if I'm wrong about it.
Is there something in the Commercial Court Guide that says if documents are not referred to in the trial, they're not to be treated as having been put in evidence?
That was my recollection. I've not chased down the reference.
It certainly used to be my practice to say that at the beginning of every trial I conducted, and I thought it had got into the Commercial Court Guide, but I may be wrong about that.
I think parties are encouraged to agree whether or not they're evidence. I see. But there is it Mr. Hamlin of Mace? He had his witness statement.
Yes.
A32.
Yes. And it's a reference to drying. Yes, that's absolutely right. And that, as far as I can see, is a sole reference in any witness statement to drying plenums. That's the only thing that there is. And that is it's pretty brief.
I understand that, but I still haven't quite understood the answer to why wouldn't a scheme deal with the plenums, given that there are 44 cassettes, which, on the face of it, would need to be dealt with.
I think that goes back then, Lord, to the question of what was the damage as at the date of 2017. Because the highest that the claimants can put it is if they can show that there is damage or was damage to the plenums as of 2022. That is as far as it goes. What there wasn't was, on the judge's analysis, cogent evidence that there was damage to the plenums as of 2017.
I think the complaint is the judge just didn't deal with it.
Well, we would
you say that's the conclusion he would have come to. And you say, and I understand entirely, that these weren't the main focus. But the fact they weren't the main focus doesn't mean that they shouldn't be taken into account if they otherwise should be.
Well, I wonder whether perhaps, I think what I'd submit in relation to that is that what one then does is look at the task that the judge had. He was being invited to adjudicate upon 4 schemes that were put forward, Sky, Mace and 2 for insurers. He says that he was placed in a difficult predicament because neither of the claimants addressed their minds to the question of what was the state of damage as of 2017 and what was required to repair or replace that damage. And he says that on a number of occasions in his judgment. What he therefore had to try to do was his best with the information with which he's provided. And he came to the conclusion that although he accepted our case in relation to the construction of the policy and that damage must occur by 2017, nevertheless, he broadened his approach out from the submissions of insurers based upon Mr. Coulson's evidence, because he regarded that as being impermissibly narrow, and doing the best that he could in the circumstances in which he found himself, found that 2018-19 was the best approximation. And we submit that that is subject to certain caveats that I'll come to on ground 4, at least that exercise of finding 2018-19 as being a reflection of the damage of 2017, subject to our grounds 1 and 2 as well, that is, as it were, a legitimate approach for him to take, and perhaps an understandable one, in the circumstances in which he found himself, and where the claimants simply weren't in a position to say, A, that there was damage in 2017 to the pleadings, B, where that damage might be, C, how much of that damage there might be, or D, what it would cost to put it right.
Well, that's the. I'm so sorry. That's the, as I understand it, the purpose for which Mr. Windsor went to the evidence. As I understand the shape of this argument, it is Sky saying we made a claim which included that there was damage to these areas. The judge just didn't address whether there was damage to those areas at the relevant point of time that he decided, at end of the POI. There is, Mr. Windsor says, and he took us to it, at the very least, cogent evidence which would have supported a conclusion that there was damage at that time. He doesn't, I think, ask us to decide that that was necessarily the case. He simply says the judge should have dealt with it, and that if the 2018-2019 scheme was the right scheme to adopt, but subject to appropriate adjustments, this is one of the matters which he should have at least considered requiring adjusting. I think putting it at least at its lowest, that's the case. And I'm not sure that anything you've said so far addresses that, does it? I mean, you say the judge could have rejected it, but that's not quite an answer to the point.
Well, partly I think that may be to do. I just don't have time to go through the detail. And it is the detailed evidence point.
But so your case is the judge would have been bound to reject the contention that there was damage to the plenum areas as of 2017.
That's not my contention.
No.
Because as I understand it, as I understand it, in 2022, some of the plenum cassettes had some damage to them. Yes?
I think that's right.
And nobody is suggesting, as I understand it, that water got into anything after the end of the period of insurance.
Well, I think
all the water ingress was during the period of insurance.
I think we say nobody suggested. Yeah,
sorry.
The expert evidence on your side was there were all sorts of myriad opportunities.
Suggesting now,
but there's an important distinction. Forgive me. No,
that's right. I've been correct quite rightly. I don't think the judge. I thought the judge had found that, as far as he was concerned, there was essentially no water ingress. No, didn't find that.
No, what the judge found is that the drying out works in 2018-19 were successful in drying out the areas to which they applied, and that was the gutters. The plenums don't have gutters, so drying out works couldn't and didn't apply there. So far as the gutters and the upslope areas, the plenums and the upslope areas were concerned, the judge accepted, and I think you were taken to by Mr. Windsor, the judge accepted that what Mr. Jessup said was that there were a number of further instances of water ingress, but that was after the drying out works, and therefore after, so far as the judge was concerned, the relevant period for determining what the insured damage was.
Well, in relation to the gutters, I think, in relation to the gutters, the judge did find that it was the gaps in the derby gum in the angles, and rejected the idea that it was some other multifarious cause of ingress in various other different places. But I'm not sure he addressed, did he, what might have been the cause of ingress in relation to the other areas of the upslopes, or particularly, which is what we're on at the moment, any other ingress to the plenums. But I think what's said against you is realistically the only method of ingress there would have been when they were unprotected by the temporary tape around the lifting strops, and therefore during construction. And that may or may not be right, but the judge just hasn't addressed that, has he?
Well, so far as, just to look at the areas, this is what I would have come to with detailed submissions. There was, so far as the upstream.
I'm sorry, I'm confusing plenums and strops.
Well,
my fault.
Lord, there's a reference I need to find from the judge's judgment in relation to what he says about the effect of drying out work. And would you please just give me a moment to find that reference, because I think it's important I take you to it.
Sorry, yes, I'm getting
But what I remembered was 180.
180.
180. It says balance liability. The entry of water.
Look, it's paragraph 157 that I had in mind.
So it's the judgment.
Oh, sorry, paragraph 175, forgive me, of the judgment, yes, it's page 416. And this is a general point in relation to the ingress of water after 2018-19. And what the judge says at the bottom of the page is that he was, this is Dr. Poole, willing to accept that this had, to his knowledge and from his investigations, occurred on only 4 occasions to cassettes 248 and so forth. Now that is a different means of ingress, and that is through things such as lapse and so forth, not the mechanism which Dr. Poole referred to as being the means by which the insured damage, the water that caused the insured damage, had entered the cassettes via the 90-degree hole in the gutters. And what the judge then says is Mr. Jessup relied on many more, but the common theme of his supplemental report is that these occurred after the period that I consider the relevant period, largely in the period between March 2020 and April 22, after the drying out work in 2018-19, when it is accepted that the damage caused by water ingress during the period of insurance was brought to an end. Now, I think it was suggested on Tuesday that there were only 14 cassettes that were pointed to, but we submit that that is a too narrow reading of what Mr. Jessup was saying. He was giving instances of a method by which water was able to get into the cassettes, but after the 2018-19 works had been completed. And so we would submit that it's not the case that the judge found that no water got into these cassettes after 2018-19. Those drying out works only related to the areas where they were carried out, and they were only carried out in relation to gutters. And plenums don't have gutters.
Yeah, I'm struggling with paragraph 180. It's really what as I understood it, the permanent waterproofing took place at practical completion, as it were, prior to the end of the policy at the period of insurance. And I thought the judge had said, as he says at the 4th line, I've concluded on the balance of probability the entry of water all occurred prior to that, i.e. prior to permanent waterproofing, as a result of the failure to utilise a temporary roof. I didn't understand the judge to have found that there was water which could have entered after permanent waterproofing.
But I think what the judge is concerned with there is the water that the judge finds gave rise to damage within the period of insurance. That's what that is discussing. That's in a context of the judgment where that is what he's addressing. And that's why he was able to find in paragraph 175, or refer in paragraph 175, to other occasions where water got in. And what he's doing there is reflecting the case that the claimants put, which was that the water that caused damage within the period all occurred, or at least the bulk of it occurred, through the mechanism identified by Mr. Poole. There's reference, of course, to upsurf areas and lifting strobs. But when you look at the evidence, Mr. Poole himself talks about the predominant amount of water getting in the gutters. There's plenty of reference to that aspect. And
so one of the important points about plenums there is that they don't have gutters.
Yes.
So any ingress there must, well, presumably through the lifting strop holes.
Well, it was certainly not through not through the mechanism that was described by Mr. Poole. No. But what generally, as I understand the position to be, is that Mr. Jessup was talking about water ingress generally after 2018-19, and that is what the judge was referring to in paragraph 135. So the proposition that no water at all got in to the roof after 2018-19 in our submission would not be correct. And my Lord, just in the interest of time, can I just say this about grounds 8 and 9, that I'm afraid that I'm not going to have time to take you through any detailed submissions today. Can I please just invite your attention to, and for your note, insurer's skeleton at paragraph 56, and that's at 4A, 8, page 230, in relation to grounds 8 to 9. And what I should have said, my Lord, as well, is that in relation to the plenums and the upsurf areas, perhaps I could just refer you to paragraphs 40 to 47 of insurer's skeleton in the Mace action, and you'll find that at core bundle A, tab 10, page 270 to 275. Now, my Lord, with that, what I was going to do is go on very briefly to address the Mace appeal, if I may. My Lord, so far as insurers are concerned, we say ground 1 is academic, because that concerns a subset of the indemnity for which Sky is claimed. Damage down to 2016 is included within damage down to 2017. The only discrete claim that Mace has is the subject of their ground 5, which is for the £10 million of incurred costs, which they say that they incurred. So, my Lord, we would say that even if Mace were to establish the cost of rectifying pre-practical completion damage, even if it could identify what that was, it would not result in insurers paying any more by way of any indemnity.
Well, it might not result in them paying any more, but it would result in a money claim in Mace's favour, wouldn't it? Sorry, a money judgment in Mace's favour. Mace would be entitled to enforce it, but it couldn't be enforced both by Mace and by Sky.
Well, Sky would be entitled to payment, I think, certainly during on the basis of the terms of the building contract. The parties agreed that Sky will receive.
Yes, but would Mace not be entitled to a money judgment for that amount if it established that which you say hypothetically could be established?
Well, it's difficult to see how the loss could be both Sky's and Mace's. My Lord, I wonder whether this is a different situation from a claimant who claims against 2 defendants and it can only enforce against 1. Here, what you've got are 2 claimants, and there'd then be a question as to whose loss it would be that would be capable of attracting a judgment. It can't be a judgment in the vacuum, I don't think. It's not merely a question of payment. A damages award or a judgment would have to be linked to a loss suffered by a party.
So do you say that whilst the building is being constructed by Mace, it's only one or other of Sky and Mace who have a proprietary interest which is insured under this contract?
Well, the proprietary interest of Mace, I think, was found by the judge, and indeed we submitted the proprietary interest ceases at practical completion.
Yes, but we're looking at damage. But looking at damage prior to practical completion.
It has a proprietary
Yes,
interest. Well,
and so does Sky, doesn't it?
Yes, it does.
And why are they not both entitled to damage which reflects the interference with the proprietary interest? As a matter of a valid claim, not that insurers should be liable to pay them both.
Well, Lord, even if that's right,
is there any reason why it's wrong? Because if it is wrong, it's a matter which may need to be addressed in our judgment, because it is a reason which, subject to your evidentiary approach, which you're at the moment treating as something you don't need to engage with because you say it's academic, would entitle them to a money judgment rather than the judgment they got by way of declaration.
Well, my Lord, it's certainly the case that Mace had a proprietary interest to 2016. The submission that we made that was rejected by the judge was that in order for Mace to recover, they actually have to do the work price of 2016.
Yes.
There's no appeal.
No.
But my Lord, they do have the proprietary interest. I think I have to go that far. But nevertheless, so far as insurers are concerned, there will be no additional sum which insurers have to pay as a consequence of any finding in relation to 2016. And my Lord, we submit that there is no evidence at all as to what the damage was in 2016.
Right.
Because that simply wasn't a question that was addressed. And but Lord, if one looks at the pleadings in the case, Mace, in fact, asserted that insurers had no case as to what the position was at 2016. I can take you to the reference in the reply if you want me to go there. I think it's paragraph 5711. But their position was, when we pleaded that Mace weren't covered for damage beyond 2016, the response was that we had no case as to what damage was as of 2016. The truth was, Mace had no case as to what damage was at 2016, and no pleaded case as to what the damage was, where it was to be found, how much it would take to rectify
that's what you've advanced in your written skeleton, and I'm perfectly happy if you want to move on quickly. For you to say that. I was just a little anxious that you were, by silence, conceding that and saying, well, I don't need to deal with it because it's academic.
Well, that's extremely
that didn't seem to me right.
I'm very grateful. But look, with that, could I then please move on to Mace's ground 5. 2 and 3 we've addressed really substantially in our response to Sky. And I don't think there's anything else that I need to say about that. But I think, need to say just a little in relation to ground 5, but only a little. My Lord, in short, the judge was right at paragraph 226 of his judgment. Can I just take you to that, please? What he says there is, so far as Mace is concerned, it has made no attempt to identify what sum was recoverable by it or in its behalf down to the date of practical completion, nor any real-world reason why it should have sued separately from Sky, and so forth. And he makes the same point, I think, elsewhere in the judgment, his second judgment, the post-judgment ruling, and that is at paragraphs 28 to 33 of that ruling. As I say, the insurers pleaded that Mace was only insured up to practical completion, and Mace didn't oppose the amendment by which that was pleaded. It had, we submit, ample opportunity both to advance evidence in relation to the costs that it now says were incurred in respect of pre-2016 damage, and indeed then to cross-examine on it and make submissions about it. And the reality is that they simply didn't do it. There were hundreds of pages of written submissions, 4 days in total of oral submissions, and by the end of all that, Mace simply had not addressed the question of what damage had occurred by 2016, how much there might have been, or what it would cost to put it right, and nor had it addressed the question of the costs for which it now claims, as to what it is those costs were for, how and when they were incurred, and in relation to what. Now, you were told one or two things by way of submission yesterday by Mr. Reed as to what they related, but as far as I'm aware, there was no evidence in the case in relation to that. Those are pure and simple matters of submission. Similarly, the first...
You're dealing with ground 5?
Yeah.
Incurred costs?
Yes.
I think it's under your case, is this right, that they just, first of all, let's just start with the pleadings. I think you said there's just no pleaded case.
There was no pleaded case as to what damage was suffered up to 2016. What's suggested is, well, these were costs that were incurred. Fine. What there isn't is evidence as to when the costs were incurred. More importantly, there's no evidence, or there was no evidence as to what those costs related to, and whether in fact they were related to damage up to 2016, or whether they related to damage beyond 2016, and whether, as we submitted, I think, in our written opening submissions to which you referred yesterday, they related generally to the cost of the Mace scheme, which the judge rejected. There was simply no evidence. And it was because there was no evidence about it, and because little had been said about it, that Mace found it necessary to write to the judge after the close of oral submissions at the end of the trial. I think 3 or 4 days later, they wrote the letter that is a supplementary bundle A, tab 12, page 203. But in that letter, they still don't identify what those costs related to, nor do they identify the damage which was incurred as at 2016, or what the amount was, or what it would cost to repair. So, my Lord, in our submission, we submit that the judge was right in the observations that he made at paragraph 226, that the evidential basis for this claim simply hasn't been established.
Well, never mind the evidential basis. Where's the claim?
Well, it's set to form part of Mace costs.
Okay, but maybe I'm just being very old-fashioned, but is there a pleaded? Is your point that there's just no pleading?
Well, I think Mace plead that they incurred costs. They don't say to what they relate, so they didn't evidence to what they related, whether they related to pre-2016 damage or not, or whether they related generally. So they did to the Mace scheme. Are you saying they? I think there's a claim for the costs.
There's a pleaded claim for the costs, and there's a quantification of those costs in their total amount.
Yes.
But you say
There's
no attempt
to explain what
to explain
yeah.
Either how it's made up or how any of it
Precisely.
is incurred in relation to damage which had occurred at practical completion. Is that your case?
Because I thought when I looked at Mace's pleading, in fact, it said something different. I mean, okay, maybe nobody else wants to look at pleadings. I'm sorry. It's very old-fashioned. I know.
Well,
I'm sorry, but
perhaps we should go there. Well,
I don't normally do this, but I mean, it's at least a starting point.
Perhaps we should go to.
We just want to look at it.
Well, can we go, please, to the Mace claim, which you'll find at page 515 in Core B, behind tab 20. That is the claim.
So, 514. Sorry,
it's Core B, tab 21B.
Core B.
Yeah. And the particulars of claim starts at page 517, and then the particulars of loss and damage are set out at 526. Now,
517. Yeah. Right. Okay. Got it. Right. This is the one I think I looked at yesterday. Right.
So if you look at the heading is particulars of loss and damage. If you be kind enough then please to turn over the page, that you'll see that at B there is a figure that says estimated incurred costs, loss costs and expenses, that as of November 22 are 11,361,000. And it's that I understand.
Sorry, I've lost you. Where?
Forgive me, page 537.
537.
37.
537.
Have the schedule.
The estimated
Incurred loss, costs and expenses as at November 22 are 11,000 odd.
Right.
And my understanding is those are the costs, that Mr. Reed very helpfully nodded, those are the costs which Mace claims and which are the subject of ground 5.
Right, but are they scheduled anywhere?
That, as I understand it, that's it.
Because there is a schedule.
There is, and the schedule relates to there's a schedule relating to the 196 million.
And then there's said to be another more detailed breakdown in the Mace Stage 3 to 4 remedial scheme estimated loss cost expense Excel spreadsheet.
I think the more detailed document your Lordship might have seen is at page 543.
Well, yeah, but there's then an even more detailed one promised at the top of page 544.
Yes.
But I thought your basic point was that none of these, there's no connection between that figure of 11.3 million, whatever. Is that right? And any of the numbers that appear in the remaining.
It's not so much that. It's rather that what Mace didn't do was establish that those costs, which are said to be 11 million odd, related to damage which occurred up to the date of practical completion.
Well, yes, because it says at B, if that's what we're doing, is they're estimated.
Yes. And they are said to have been incurred as at November 2022.
Right.
But there was no explanation as to what they comprised,
okay,
or the detail of the costs, or as to what they related. And of course, they would only be recoverable if it could be said that at the very least, and at its broadest, that they related to damage up to the date of practical completion. And of course, our case in relation to damage at practical completion was that Mace hadn't established what, when, or how much had been incurred to practical completion. And there was no way then that we at least could test whether these were losses or costs which related to damage as at practical completion.
So when you read paragraph 54 of Mace's skeleton for this appeal, which is the one I think I was looking at, so page 253 of Bundle A, or Bundle A, the claim that Mace say they were wrongly deprived of was a claim worth circa 10 million, and I think the number I remember seeing was 9 point something odd million.
Yeah.
Is that supposed to be a subset of the 11.3 million?
I think it is, Mr. Reasonable. That's my understanding. I think the 11 million is the sum that went, insofar as it's pleaded anyway, that's where it's pleaded.
Right. But
which relates to the
so that's the sum total of the pleadings.
Yes.
So,
and there was no evidence left that explained what those sums related to, or how it was said that they related to pre-2016 damage. And the reason for that was that perhaps if we're looking at pleadings, I wonder whether perhaps I could just invite your attention further on to the Mace amended reply. And if you'd be good enough, please, just to go to, I think, paragraph 57, 53. 53L, page 707.
Can you give me that again?
I'm so sorry, page 707, and it's behind tab 24 of Core Bundle B. Now, this was an amended reply in response to our amended defence, in which we pleaded that Mace was not insured for damage beyond practical completion, setting out the contractual scheme of the building contract. And this then was in response to that, and what was said at 53L was, for the avoidance of doubt, even if the defendants are correct that no insurable rights are interested in practical completion, that wasn't quite how we put it, but Mace's claim to indemnity in respect of damage occurring before and on the date of practical completion remains unaffected. Mace notes that the defendants have pleaded no case as to that damage. Well, of course, it wasn't for the defendants to plead any such case, it was for Mace, and it didn't. It had pleaded no cases to that damage at all. Now, when we come to those losses that are referred to in that paragraph of the amended defence put at 11 million, there was nothing by way of evidential support for that, or explanations as to how Mace said that those were somehow losses which it had occurred as a consequence of damage up to 2016. And that's why it felt compelled to serve the letter that it did after the conclusion of the trial. But even then, that letter was not able to point to evidence that was led during the trial which established what those costs related to, or how it could say that they're indemnified.
But this is not something the judge has dealt with at all, is it?
Well, I think what he has addressed is in the paragraph of the judgment we've just looked at. He's just said that Mace made no attempt to properly to quantify or to evidence. If we go, please, back to the judgment. we go to paragraph 226 at page 436. So far as Mace is concerned, it has made no attempt to identify the sum, but what sum was recoverable by it, or on behalf down to the date of practical completion, nor any real-world reason why. Well, that's a different point. But it was that they had simply made no attempt.
Well, we have the answer. I mean, we have what Mace says at 56 of their skeleton and 57. I mean, their point is that this was dealt with evidence and by the experts, and it's just, and what they don't understand is why this wasn't something to be dealt with at the remaining quantum.
So far as the experts were concerned, that there may be that the expert looked at a number. All the quantum experts were doing was looking at a number. There was no evidence as to what the sums in question related, and the quantum experts weren't concerned with that question.
Well, we haven't seen Mr. McGowan's witness statement.
You haven't, but the analysis of the judge, but my lord, our submission at the end of the trial was, and our submission when in the consequential hearings, was that there was no evidence as to what these costs related. And that essentially is the finding of the judge at paragraph 226.
Well, it's a pretty light way to weigh off a claim for £11 million, which hasn't been abandoned on the face of it. I think we might have to trace through a little bit more carefully what's happened in relation to that claim if you're going to say it just doesn't arise. And it gets the impression here the judge thought as a matter of principle that there wasn't any separate claim to that of Sky. That's the impression one got from reading that. But to simply say, well, there's this claim on the pleadings for 11 million, it hasn't been pursued, I think.
It's perhaps not that it wasn't formally pursued, but it's rather that the judge was saying there was no evidential basis explaining what it was for. It just wasn't addressed. And the judge makes the same point in the post-judgment ruling. Perhaps I can just give you the reference in the interest of time, I'm mindful of the time. But at paragraph 32, he repeats the fact that in his judgment he held that Mace had not made any attempt to identify what, if any, sum was recoverable by it or its own behalf, down to the date of practical completion. And says, well, it's now too late to do so. So the judge had considered it. He just said, well, I'm afraid I've not been provided with the evidential basis for it. Well, I don't know that's a convenient moment.
Yes. 2 o'clock.
Court is available.